Welcome to Real Estate I Love It podcast. I'm Shelley Hoffman, real estate expert and community advisor. Join me and various guests who are expert in what they do, such as home inspectors, mortgage brokers, investors, wholesalers. There are so many aspects to our industry that most people are not aware of, and I'm here to help you learn about them. I'm an educator by trade, and this podcast is to educate you in the world of real estate. Hey everybody, welcome to another episode of Real Estate I Love It. We are super lucky today to have Karin Sloan Delaney with us. She's a local lawyer here in Baldwinsville. She deals a lot with estates. And if you remember, last month we had a gentleman on that was talking about estates and life use, and we had a lot of questions. So we asked Karin to come and just give us a little bit more explanation. How are you doing today, Karin?
I'm doing great. How are you?
Doing well. So just kind of start off the show, and I know Christy, Steve, Rob, we'll all have questions for you, but can you give us just kind of go into why, when you get that phone call and someone says, should I put my house in a trust or, the estate, what's the benefits, any problems with that?
Sure. So that's a very, very common question that arises when people meet with me to do their estate planning. And usually they have heard from a family member or a neighbor, or they read an article, or they Googled, or something has come across their radar that they should have their house in trust. And there's a lot of different trusts out there in the trust land. And probably the most significant or the most common question that comes up is, should I put my house? I want to protect my house. I want to protect my assets. And so we use one type of trust for asset protection. And then another issue that comes up and not quite as frequently, but it does still come up, is I want to avoid probate. And so there's a different trust that we might use just to avoid probate. So those types of trusts, purely to avoid probate and to provide some asset management, are called revocable trusts. These are both trusts that we create during our lifetime. Trust can also be created in your will. So those are trusts that we create the terms of while we're alive, but they don't actually come into existence until we pass. But the type of trust to avoid probate is a revocable trust. The revocable trust is exactly what it sounds like, right? It's revocable. We can change it. We can amend it. We could rip it up and get rid of it. It's very, very good at removing that asset from the probate process, not so good at protecting the asset from potential creditors. Probably be the most significant creditor that people are afraid of these days is the cost of nursing home care. We like to use revocable trusts. I'll be honest, a lot of my clients have real estate here in upstate New York, and maybe they also have another house somewhere else warmer. On a day like this, I cannot imagine why they could possibly want to be anywhere else. But for those people, avoiding probate is very, very beneficial. When we own real estate in multiple states, we subject our estate to the probate process in those different states. So if I own a home here in upstate New York and I have a vacation home down in South Carolina, if I just keep that house in my name alone, then when I pass away, there's going to have to be a probate process here in New York. There will also have to be a probate process in the state of South Carolina. So very often, again, if the concern is not so much asset protection as it is just avoiding probate, we will use a revocable trust to pull those properties in under the umbrella of the trust and avoid the probate process. It's very, very beneficial, and cost savings, time savings, all that. The other type of trust, and I probably talk about this type of trust nearly every day, is irrevocable. And the irrevocable trust, again, the primary reason that people are concerned about asset protection these days is in the event they need nursing home care. And just to put it into perspective for all of us, the cost of nursing home care this year in our area ranges from about $15,000 a month to about $17,000 a month. And, we pay for that care one of three ways. One is we pay out of our pocket. We write that check. The other way is with long-term care insurance, if we're lucky enough to have it. And the third way is by applying to the Medicaid program. And because Medicaid is a government program that we need to qualify for based on our assets, we're real, concerned that should we need nursing home care, that we've protected our assets enough so that there is not eventually a lien on our home, or, that we would be forced to sell it to pay for our care. So that is, really, like I said, I probably talk about that type of trust every day. And the home tends to be, for a lot of people, it's one of their most significant assets. It also has a lot of emotional attachment to it, right? It's our home. It's our safe place. And so I think that for those reasons, people, really feel compelled to try to protect it as much as possible for their kids, sometimes for their spouse, that sort of thing. And so really that's where it comes up. And I tell people that, these trusts do a great job. They really do a great job at protecting assets from long-term care. We transfer our home into the trust by deed. These trusts, if drafted properly, provide us with all the benefits and burdens of home ownership, pretty much. So we continue to pay our real estate taxes and make ordinary maintenance and repairs on the property. Again, if drafted properly, we're entitled to keep property tax exemptions. And we don't really know that our house is even owned by the trust, because we're just living in it. And when we get our tax bill, it mentions our trust. So again, if properly drafted, these trusts really do a great job. It sometimes gets a little bit sticky when we want to sell our home, and we can talk a little bit about that. But for the most part, it's pretty smooth. A third way that people change title, sometimes to protect assets, sometimes to avoid probate, sometimes just to make things go smoothly, is not to use a trust at all, but to deed the house now and retain life use. This used to be something that we did very frequently. There was a reason why we did it instead of utilizing a trust. There are certainly some advantages and disadvantages of that arrangement. And we're seeing a lot more trusts as a result these days.
Can I go back, Karin, and ask you something you started with in the beginning, which is you can start the trust while you're still alive, but you also said that it could be part of the will. If you make putting everything together in a trust as part of the will, how does that work with probate? Or I'm assuming that.
Right. So for trusts that are created under our will, we're not worried about avoiding probate, right? So it's usually a trust for the benefit of a minor, or, I've had situations where we're not really having the discussion about probate so much, and we're not really having a discussion about long-term care. But sometimes I just have someone who has a significant other, someone that wants to continue to live in the house. And so it's not out of the realm of possibility to incorporate trust provisions in your will that would provide that person the capability of living in the house for a period of years or until they pass. But you certainly are not going to avoid probate that way.
Is that a term where maybe life use still comes into play? like if someone passes, then, you know, a lot of times people are significant others. They never really married. They want the house to eventually go to their kids, but they want their partner to have the house. Is that something like life use or?
Yeah, you can use life use. Certainly, I'm sure Christy has probably seen these arrangements go sour, as I have too. It's really, you know, I try to have this conversation, a very honest conversation with clients when we're trying to do things like this, because it can get very sticky, right? So if we're giving life use to someone like that, what if they trash the house? You know, what if, you know, who knows? What if they don't pay the taxes? And so that's where these arrangements really go sour. And then we're talking about, can we evict this person? Can we hold this person responsible for, you know, the fact that they turned the house into a feral cat rescue, or you know, I mean, these are legitimate things that happen. So we need to consider all ramifications when we do things like that.
Christy, can I throw that to you real quick? Because obviously, you know, Karin mentioned it's something you would see. Is that going through the sales process that you see it, or another aspect of your law?
It's mostly the sales process. That's when we will kind of have to grapple with somebody who's been using it for whatever term, because most of the folks who are entitled may not really go there ever, right? Especially if it's the partner of your mother or father who just happens to get to live there. So that's when it starts to become very real, is when they see that it's not in good shape, or that person's not leaving, or whatever the case may be, if they haven't passed, right? So that's a whole separate thing. I personally don't love life use and the whole deeding into, usually it's kids, right? You know, you have your 3 kids, you put it in their names, and I will reserve a life use for the remainder of my lifetime, because we're really banking on the idea that those 3 kids are going to continue to get along and make this work. And that is just, unfortunately, really not the case more often than not. Could be one bad apple, could be all of them are, but they just cannot make this work. So even getting to a point of agreement to say we want to sell this for X amount of dollars is practically impossible. And then I still need everybody to sign off. And I don't know that that's going to happen. So it's usually when we finally are ready to move on and get rid of the house that we see those issues, but it is definitely not something that we love.
I agree. Yeah, I agree, Christy. I see the same issues. Or sometimes someone's been granted life use, and like you said, they're not actually using it. And then when you go to sell it, you have to find them so they can relinquish life use, you know, and sometimes we can't find those people.
Yep.
And for all the reasons Christy said, and even more, you know, I have situations where people have deeded their house to multiple children. As Christy said, the most common thing is they don't get along, and they don't. I would say 9.5 times out of 10, something goes wrong. But also a very difficult situation if one of your beneficiaries or one of your children predeceases you. And so I've had that situation where there was a deed to 3 children, and one of them predeceased. There was nothing that would suggest anything except that we had to look at that person's will to determine what happened to that interest in real estate, which unfortunately went to 2 minor children. I mean, we're just talking about a real estate nightmare in that case.
Yeah, it really adds a whole lot of complication with the 3 kids, with the children, because all of you have to stay judgment clear too, right? And there's no guarantee of that. And if one of you doesn't, then yeah, I guess we could take it out of your proceeds when we sell. But most of the time they don't want that, right? They want their quote unquote third, because in their brain they've been thinking, all right, this house is worth $300,000. We sell it, I'm going to get roughly 100, but you just racked up, you know, $50,000 in IRS liens that have to be cleaned up before we close. Yeah. So you're not going to get anything, and you're just going to get mad about it and not want to close. So there's so much in the family realm, and then obviously if you have people who are not family, then it's a separate ball of wax. But
I just want to throw it. So Steve, question for you then: if it's life use, and Karen and Christy, you can jump in here. But if it's life use, I mean, obviously someone needs to be insuring the structure of that home. Is the life use person more of a tenant, or do they have homeowners insurance? Like
so typically it's most of the carriers. There are a few outlier carriers out there who are a little bit like uncomfortable with the way that the named insured process works. But primarily on a life use situation, the person living in the house has a homeowner's policy, traditional homeowner's policy that will cover them. So they don't have to get a separate renter's policy to cover their possessions and liability. So what happens is, as an additional insured, the deeded owner, so in this case, the children or whomever they are, end up listed as an additional insured, additional interest on the property. But let's say mom is the named insured. Technically, mom is the deeded owner, but she has life use, so therefore she gets, the traditional sort of coverage that one would expect out of a normal homeowner's policy.
Gotcha.
And the trust works the same way, with the exception that some carriers want the trust listed as the named insured, and then the occupant of the house, which is usually like the person that the trust is in the name as the behalf of, is listed as an additional insured also on the policy. Other carriers are like, look, we can't handle trusts. The way our policies are written or structured prevent us from being able to appropriately take care of of the trust situation. So they just, it's not that they wouldn't, but they, in order to change it, would have to go through a significant filing change with the state, and don't really find that to be valuable because they're just not hit up that often. I have a follow-up question though for Karen and Christy. You may have something to say about this too. But with regard to life use versus the trust, I mean, when you have the trust set up, isn't one of the other benefits is that you can have a trustee? Because inevitably, one of the three kids is going to take over the responsibility of selling off the house when the parent passes, and the lion's share of the work ends up going to the trustee. Or if there isn't a trustee, the lion's share of the work goes to one of those three. Inevitably, the other two are going to sit back and say, yeah, we're still splitting it 3 ways. And the third person says, yeah, but I did all the work. And they still want to split it 3 ways. Whereas when you have a trustee, and Karen, correct me if I'm wrong, when you have a trustee essentially can be paid for the work that they've done. And then out of the remaining balance after they're paid, it still gets split the 3 ways. So
for sure.
Is there also a benefit for that as well?
Oh, for sure. Yeah, there's a lot of benefits of the trust over the reserve life use. I will tell you that probably the only benefit of the reserve life use is just the ease of doing it, right? It's a deed as opposed to a trust document. But yes, absolutely. The trustee of a trust is they're the manager. They're the manager of the trust. So they're the person that is person or entity that would be responsible for the sale. New York State has a statutory commission that trustees can take, and some trustees do take them. You can also incorporate commission into the trust document. But yes, they would be entitled to a commission. And if they're also a beneficiary, then be split 3 ways.
Go ahead, Rob.
I've got a bunch of questions, but
Oh boy.
a lot of these issues I run into with my clients, and now, first of all, the deed, if you deed it over your house versus moving it into a trust, will that give them the same protection for nursing home? Or is one better than the other?
Mm-hmm. Yeah, that's a good question. So the reason we used to do deeds with reserve life use more in the old days, and by the old days, I'm saying pre-2008-ish, is because when we were talking about Medicaid eligibility, there were 2 look back periods. And what that means is when we go to apply to nursing home services, Medicaid nursing home services, they require a certain period of time to look at all your financial records. Pre-2008, that time period was 3 years, unless you had a trust, and then it was 5 years. So we used to use those deeds more back then because it called for a shorter penalty period. We had 2 extra years that we could work with. And for some people, that's significant. The penalty period, Medicaid redesigned Now the penalty period is 5 years, no matter what. And so, so now we're looking at that 5-year period. If we do a deed with reserve life use now, and I do not do them often, there are some situations that call for them. They're few and far between. But if mom or dad then needs nursing home care, so mom or dad's in the nursing home, kids own the deed, mom or dad has life use, and it's expensive to keep the house going with nobody in it, right? We're trying to pay the utilities and the taxes and everything. And so family says, well, that's it, we're selling it. And so if that house is sold, mom or dad's in the nursing home receiving Medicaid, that life use has a value for legal purposes. And we determine that value through mortality tables. So let's say that value ends up being worth $30,000, $40,000. Mom or dad's going to receive from the sales proceeds that amount of money, and which means it's going to go directly to the nursing home. So in general, yes, the deed with reserve life use offers the same amount of protection. But if you sell the house while you're alive, then you're going to lose a little bit.
Okay. Now, also, if you deed it, and in the scenario we talked about, Christy brought up with deeding to the children, that's most of the time the children will get along and they work in the best interest of the parents. But I've had cases with my clients where either one of the children went through an ugly divorce, mm-hmm. or one of the children had a business that went bankrupt, or had a lawsuit. Now, when you deed it to your children, do all those things affect it? I mean, can you build that into the contract, or how do you prevent that stuff from throwing a curveball into it?
So all of those things can potentially affect that arrangement and the title. Here in New York with divorce, it should not create a problem. There are some states, however, where it could create a problem. And I've had that situation with an out-of-state child going through a divorce, and the deed has caused an issue on their divorce. I've also had the situation where I had one beneficiary that was going through a bankruptcy. So potentially, yes, these are reasons why we don't do them. And Christy, don't cringe here, but sometimes we use a power of appointment in these deeds, and title lawyers, real estate lawyers don't like them, and I understand why. And I really understand why. But what that means is it reserves in mom or dad the capability of exercising this power to change the beneficiary of the deed or change the owner of the deed. Now, so you can imagine from Christy's perspective how absolutely miserable that will be when you're trying to look at title. Did mom or dad exercise this? How do we know? Do they now have capacity to release that? I mean, these are all problems. So these are all reasons why, we prefer the trust over these deed arrangements, because I'm happy to hear that 99% of the time, in your case, people get along, because I would say it's the exact opposite from where I sit. But all reasons why we don't want to do them. They potentially could affect title, and it could be really bad.
One more question.
Yeah.
Actually, I got a few more, but I'll just ask one more now. Okay, so let's say we move the house into a trust. What if you could explain a little about what the owner, or now the tenant, was the prior owner of the house, what do they give up by moving it into a trust? can they renovate it if they want? Do they need the
Mhm.
trustees' approval? So can you just
Mhm.
explain that, what you're giving up?
Yeah. I would say in most situations, they really don't give up much at all.
Okay.
They are, I guess what you give up, people always say, can my daughter, who's a trustee, can she sell the house out from underneath me? Not really. We have so many protections in New York State for homeowners, and people who live and reside in the residence. And in this type of an arrangement, I think if someone truly was trying to push someone out, I just think you would. I don't know. I don't know how successful they would be in that scenario. However, a good reason why we want to pick good trustees, right? And I always have that conversation with clients as we're developing who should be the trustee. It's always good to have a friendly trustee, for sure. But if for the most part, the parent, or the life use beneficiary, so to speak, pretty much lives their life and does what they have to do. The trustee really never even gets involved unless we have to sell the house. And that's really because legal title is in the name of the trust. The trustee would be the person who would be meeting with Christy to handle the sale in that situation. So what are they giving up? I suppose this feeling of complete control. Beyond that, when we're dealing with a house, they're not really giving up a lot.
Okay.
I always tell people it's much different if we're putting $100,000 of cash in the trust, okay? Because these irrevocable trusts, the deal is, is that we do have to give up some control. And if it's $100,000 of cash, we're only entitled to the income interest in that $100,000 of cash. Now, the way income interest translates with a home is that we keep basically something that sort of looks like life use. And we keep exclusive use and occupancy of the house, even though it's in trust. When it's $100,000 of cash, we're only getting the interest off that money. And what we're giving up in that case is the capability of reaching in and taking out $30,000 to go buy a new car or something. So the two assets are treated differently in this type of trust.
Now, can the owner put an addition on the house if they wanted to?
Yeah, I think all things are possible, especially, again, if you have a friendly trustee.
Mhm.
How to finance that might become difficult. So, I tell clients, listen, if we're going to do a trust like this, you're not going to be taking out a home equity loan, and you're not going to be taking a mortgage out on this property. This is really, we should probably be using funds on the outside for that. And I guess if it was a situation where we weren't quite sure, I would certainly want an agreement between the trustee and the parents or the original
Do
grantors.
they have to use money to do any renovations? Do they have to use money within the trust, or can they use personal assets?
They can use
renovate the
personal
house?
assets.
They
They
can.
can use personal assets. Now, not every situation is, everything is a little bit different. So we take a look when we make that decision. We have to look at the health of mom and dad. We have to look at the potential risk that someone, on the Medicaid end would say, well, it looks like you made an additional gift to the trust by doing this. There's a lot of factors that go into major decisions like that. But in most situations, we can pretty much arrange an agreement between all the parties and use the money outside of the trust.
I was actually thinking about the finance piece of it. So let's say that it's someone who, we'll say they're in their 40s and they put their home in a trust, and it's this big 2-story colonial. And when they turn 60, they realize we really want 1-floor living. Mm-hmm. Now, if it would be great if they sold their home, had the cash from the sale of the home to buy the ranch. But if they don't, and it might be Karin or Jason to answer this, but if they need to finance, so this house is in the trust, they want to buy another house, can they buy it in the trust, or do they have to buy it and then move it into the trust if they need to finance it? Like if they're going to Jay for a loan to finance this home, how does that, you know, and this I think comes back to when we were talking last month about sometimes it's tricky to sell, right? How would that work?
Well, I tell, because this is probably the biggest question that comes up when we do these trusts. What if we want to sell this house? And I tell people that trusts buy and sell real estate all the time. What becomes difficult, it's easier if you're downsizing, right? So if you can walk away from the closing with $200,000, it gets deposited into a trust account, and then your purchase is $200,000 or less, then that's our goal. I did have clients a few years ago that upsized. And again, these are all considerations that we discuss before we do a trust. These folks were in their 80s. Upsizing was not something that I had anticipated, and I don't think that they did either. Maybe they did, I don't know. There was no way they were getting financing, right? Because the trust does a great job at asset protection. Remember, this is to protect the asset from creditors. What people like me, when we're talking about creditors, I'm thinking of, the county or the state. But if I'm representing the bank here, I'm going to say no way. Because if I have to foreclose on that, who am I, what's my ramification? We're limited. So again, I would never recommend this type of trust for people in their 40s. So this is definitely a conversation that we have with folks upon retirement, unless you're retiring in the 40s, and then I want to know what you do. But these are all conversations that we have ahead of time, because I think that purchasing, upsizing, or needing to take out a loan is probably impossible. I don't know. Maybe Jason could add to that.
And a quick question, Jay, just before you answer, if I could, just because it's tied to this, what if someone has a loan at the time, are they prohibited from being able to start the trust in the first place? Do they have to own the house free and clear to begin with as a prerequisite? Yeah,
they don't. There is a federal law, the Garn St. Germain Act, that would permit. So what are we worried about? We're always worried about the due on sale clause in the loan agreement or the mortgage that says that you can't transfer. If there's an existing loan, you cannot transfer it to anybody else, or it will invoke, then the loan will have to be paid in full. So there is a federal statute out there that that would allow us, as long as our creators of the trust or the grantor or the settlor is still the primary beneficiary for his or her lifetime. I will often, not always, but often have the conversation with the bank ahead of time as well. And I really have only ever encountered a problem once, where the bank was not okay with it. Okay. I don't know if anyone else on the panel has anything to add to that.
In our world, from the lending standpoint, if it's irrevocable, we won't lend on it. That's kind of a common across the board. So it has to be revocable. And then basically it's fine. It's just the title. The title of the home is going to the trust, and there still has to be a individual guarantee, credit and income and all those things. So because a trust does not have credit and whatnot, so it's individual. But then the title piece of it is with the trust. So I've run into a few people who've tried to do a mortgage and it's in an irrevocable trust and they can't do it. Most of them will just try and do something. Use alternative means. I have had a few that have actually changed it and changed the type of trust.
Hey, Jason, with the trust, if there's trustees inside that trust, or Karen, you can answer as well. Do you have to run credit checks on them too, since they have a little bit of control on the trust, or is it doesn't matter? It's just the trust itself.
Yeah, we just whoever's gonna, basically whoever's gonna be on there. So most of the time, like a trustee, usually the trustee typically is the person who owns the home. I mean, the trust owns the home, but who previously owned the home. So it's their asset that they decide to put in trust. So they would be the ones that would be going on the mortgage. I don't know if I ever remember a trustee really not being, the trustee's the benefactor. So, right. Correct me if I'm wrong, Karen. But
for revocable trust, that's true. Most of our revocable trusts, the people that create the trusts also act as the trustee.
Yep.
And they're also the beneficiary for their lifetime. Now, for irrevocable trusts, they are different people. And, as Jason said, that I've never seen a situation where we could get a mortgage once the property was owned by an irrevocable trust. I just don't think it's possible.
Which makes sense.
Yep.
I think the only thing I want to clarify hearing all of this is that trust, from where I sit, trusts don't ever own property. It is not owned by the Christie Brightman Trust created on January 31st, 2022. It is owned by the trustee. So it has to be in an individual trustee's name. Otherwise, you have conveyed something to nothing, basically. So that conveyance doesn't count. We've had a few situations where people who did their own kind of, I bought my trust agreement on, LegalZoom.com and whatever, and I did this all myself, who've showed up with a deed into a trust from way back when, and everybody's gone, nobody knows what, but it's in this trust. We're like, well, it's not. So you now have a really big problem because nobody knows anything about it. Almost everybody's gone, but here it's at in a trust. So trusts can't own property in New York. I think they can in other states because it's a different structure or whatever they have. But here it is in the individual trustee's name. I don't think that changes anything, right, from the lending side or anything like that on the irrevocable piece. But it has to be in the individual trustee's name. So it's technically an asset of the trust, but the trust does not really own it from a title perspective.
Correct. Yeah.
Dave, you had a question?
Yeah, just curious in regards to the changing of trust. You mentioned that they can be changed. I'm assuming that you can change a revocable trust to an irrevocable, but can you do the opposite?
That's a good question. So, yes, much easier to change a revocable to an irrevocable. Can an irrevocable be changed to a revocable trust? It can. It's again, we want a well-drafted irrevocable trust that would permit that. Sometimes it's a few step process. It's not just as though we say, okay, we hate this thing. We're going to go right to a revocable trust and sign an agreement. And there is a few steps involved in that. There's a reason why they're irrevocable. So a common situation, and again, these are all conversations we have before we even start the irrevocable trust process, because we don't want to be in a situation where we essentially have to revoke an irrevocable trust. The reason we're doing it is very often to protect these assets from long-term care costs. So if we then do something that erodes the integrity of the trust, we're basically just might as well have all the assets in our name alone. So can it be done? Yes. There are very limited situations when we do it. I had a situation about 5 or 6 years ago where people came to me. They had a trust done at a different law firm, and and mom, when she signed the trust originally, she was not in good shape. But sometimes we do it because we figure we don't know the future. It's a roll of the dice. Let's just see if it works, and we'll try to get through that 5 years. Sometimes there's really no alternative or no good alternative. And in this case, she had signed it and needed care within 2 years. And so we had to basically revoke the irrevocable trust. So it can be done. We essentially, not to get into the legal nitty gritty, we have to have everybody agree to it. We have to have the trustee, the eventual beneficiaries. We pretty much have to have everybody on board, but it can be done. There might be a better alternative. So, sometimes we have escape hatches in these trusts where we can distribute money out to somebody else that might be able to pay for care. So there are escape routes that we can draft into these trusts. But again, when we do that, we're eroding the integrity of the trust to begin with, and we only want to do it if we're really caught and in a bad situation.
Now, if someone's got the trust and they're past the 5-year period, and then they take assets from their personal funds to put in an addition or do something to the house, are those funds now part of the 5-year look back period, a new 5-year period?
Well, the way the 5-year look back goes is that, we have to think of it as in terms of a look back, right? So we don't ever know, A, if we're ever going to need nursing home care, and B, when that day will be. But if we go to apply for Medicaid and they ask for the prior 5 years of financial records, and they see, we got contractor payments, all this, happened 3 years ago. Is there a potential problem? Sure. There's always a potential problem. That's what keeps people like Christy and me in business. There's always a potential problem. Have I seen improvements made to the home within 5 years before needing Medicaid, and they have been fine?
Okay.
And have not interfered with the Medicaid process? Sure. I've also seen where it's gone wrong. So I'd like to tell you that the law is applied the same way every time in every situation, but it isn't, especially in the Wild West, as we call it, of the Medicaid world. It's rarely ever applied the same way.
Does anybody have any additional questions or look for clarification for something Karen's talked about today? I got to tell you, Karen, the one thing I think I took away a lot, but the one thing is it's not set in stone. So, when you're talking to people and they say, oh, you should put this in a trust and do this, and this, or my parents did, check these boxes. It seems like you really need to sit down and put what are your specific needs, right? It doesn't seem like it's a standard form, to Christy's point, of zoomlaw.com. Here's your trust. Yep.
Yeah, for sure. And it's a really good point. So yeah, there's a lot of different states, as Christy mentioned, treat trusts a little bit differently. I think if you're going to have this conversation, because people, I will tell you, it's the number one thing when I sit down with people, I need a trust. And I always say, well, why do you think you need one? What is it? What are you trying to protect, or what are you trying to achieve by having it in the trust? Trusts are not right for every person. It's important to have the conversation, legal and otherwise, before we sign the documents, because the worst thing is to have a trust that we need to get out of, or that causes problems later on. So it's really important to have that conversation ahead of time to figure out if a trust is actually going to achieve the goals that the client has. It doesn't always. They're not right for everybody.
And on that point, from where I sit, because technically speaking, I could form a trust. I shouldn't. I should not have this conversation. I am not qualified to have this conversation with people. I can say generically, I know X, Y, and Z about them. However, you should talk to somebody that's going to have an in-depth conversation with you about your needs and what you are trying to do with a potential trust. Not your parents' friend who happens to be a lawyer and works as general counsel in some local business. Mm-hmm. That's not where you should be going for this. This is very much, like I always say, I don't want my dermatologist doing my heart surgery. So you do not want your parents' friend's criminal law buddy doing this type of work. I'd prefer that they just stay in their lane. I don't do criminal law either. I don't think Karin does. They're more than welcome to keep all of that stuff, and we will continue doing what we know and what we do best, because that serves everybody, really. Because from where I sit, you have a terrible trust agreement that we need to fix. It's really difficult to fix. Like I said, we've had deals blow up because of trusts. So it's not something to just enter into lightly or kind of on any sort of like cavalier basis, because there are lots of different ways to effectuate potentially what you want to do. And it's what's right for you ultimately, and your situation, which is not, again, across the board the same thing. So I implore people, please call somebody who does this regularly all the time.
Well, and I'll tell you, it's the other pieces too, like even to Steve's point of insurance. You know, we just think we call up an insurance broker or an insurance agent and they are like, yep, absolutely, we can cover you. You don't think about the pitfalls and that too. So it's not just talking to someone like Karin. It's look at your whole big picture and what all does it affect. And then bring that information to the meeting with someone like Karin so that, you know, you're not chasing your tail later, in my opinion. But I would think that's important.
And I think that also raises the issue of, you know, it's good to have a good team of professionals that works together, right? Because I look at things from one angle and one lens. Christy looks at it a different way. Shelley, you're going to look at every single person in this panel looks at things with a different lens. And so it's really important as we're, you know, developing the right solutions for clients to reach out to our team to make good decisions.
Yeah. And I think prior to really knowing you, what you've done, I would have looked at someone like Rob to tell me, should I go into you know, because you're thinking financial advisor, they're going to advise me financially what I need to do. And to Rob's point, he refers them to someone like you. But it's just, I don't think we always know all the little details, and that there's usually somebody that specializes in that, and you want to go to them when it's something so important. So, well, thank you, Karin. I guess we're out of questions for you at this time. We reserve the right to reach out to you later with more.
You have a good lawyer. Jeez.
Oh yeah, you know, we go to Christy, everything real estate. The poor girl, I picked her brain quite a bit in the last, I don't know how many months we've been doing this, but all right. Well, everyone enjoy your Monday, and we'll talk soon. Bye.
Everybody.
Thanks,
Thank you very
Karin.
much.
Very good job.
Thanks, Karin.
That's it for this week's episode of Real Estate I Love It. Be sure to subscribe and leave a review on whatever stream platform you're using for your podcast. See you next time.